and then briefly about the cost of noncompliance, as Tanya mentioned. Before we start, though, just a few items I like to go over first, and those are definitional. What's the difference between privacy versus data protection and security? Privacy is about the use of personal information and the right of an individual to control it, while data protection is the management or safeguarding of that information. And you might think of it, it's the means by which you implement the privacy standard. And in terms of data protection and security, you have obviously the security standard of whether there's any protecting against unauthorized access, as well as storage components to make certain that it is accessible and not corrupted. Another important definition is incident versus breach. From a legal standpoint, these are very important to distinguish. Should you have either of these events, you want to be certain that you're calling it the correct thing. An incident is a security event that compromises the integrity or confidentiality. A breach is when there's a confirmed disclosure. So an incident is a breach, but a breach is not an incident. And finally, from a definitional standpoint, we have personal information, we have non-public personal information, we have sensitive customer information, personal data. I could keep going on different variations, but they all differ depending on the statute or the regulation. The important part is to consider it broadly. Many years ago, we thought of it in terms of name, rank, serial number, account number. It's much, much more. It's anything that can identify a person. And like I said, there's variations depending on what set of regulations you're acting within, so just be mindful of that. First and foremost, from the regulatory framework for privacy in the US, we have no overall federal law. There are specific industry laws. We have Gramm-Leach, Ic3, HIPAA. There have been several proposed federal laws. None have gone very far. Right now, I don't think it's likely that we will see any real activity, given the current crisis going on. We do have the California Consumer Privacy Act, which is what has really been the focus of a lot of attention in the regulatory world for the last couple of years, as it begins to take full effect with, mind you, enforcement starting here July 1st. That CCPA is modeled after the EU's General Data Protection Regulation, so you do see some similarities, particularly in the scope and fashion that they're addressing things. In terms of the states, in New York for banks, we have the Department of Financial Services cybersecurity rules. In 2019, we also had Nevada and Maine actually pass legislation. And the last arrow there, those are all the pieces of legislation that got introduced just in January and February of this year. So it was a very hot item before being replaced by other hot items. We'll talk more about those individual states later. So a little bit about Gramm-Leach, and I'm sure everybody was hoping for a real in-depth discussion and analysis of about 30 minutes on Gramm-Leach. You will have to find another program for that. That's not going to be the purpose of today. We've all dealt with this for a long time. We're quite familiar with it. We know it applies to financial institutions. That's obviously this group. Other groups continue to find out that they're included within that definition. Non-public personal information. Now here's one I do want to remind you about what's actually in the Act and the regulation, because we know it's consumer information, but provided to obtain financial products or services, or resulting from a transaction, or in connection with providing that financial product or service. That's going to be important when we look at some pieces under the California Act. So keep in mind that idea of it being in connection with a financial product or service becomes a little bit more of a factor to consider. And no one can forget about our lovely customer and consumer notices and opt-outs that are regulated under the Act, as well as the limitations on disclosures and exceptions. So this is actually an example of a privacy law. Moving into the interagency guidelines establishing information security standards, this is a data protection law. So it's actually implementing pieces of Gramm-Leach. They have some additional context around the definition of customer information. It describes the safeguards that need to be in place to secure for the security and confidentiality of the customer information. You're required to have the incident response program. Customer notice is required if there has been an incident. And in this context, an incident is if there's been unauthorized access to sensitive information, if the institution determines that misuse of the information has occurred or is reasonably possible. So there is some gray as to whether you actually need to provide the customer notice and the context around the incident, and whether, in the bank's discretion, you can determine that a misuse has occurred or is reasonably possible. So that does give a fair bit of flexibility. And in the context of the interagency guidelines, sensitive customer information is really that combination of personal identifying information with things like the social security number, the driver's license, the account number, anything that can basically get access to a customer's account. And just as a reminder, if you do have an incident, do not forget about whether a SAR is required. So we've got the customer notice, we have a possible SAR, and then you will have regulator notice, which is written a little bit different than the customer notice section, which is basically upon awareness. You need to inform your regulator, even if you don't have to notify the customer. In the financial services sector, we also have the Fair Credit Reporting Act. This is a privacy regulation, or act and regulation. There's obviously a lot of components about this act that apply more to the specifics of consumer reports. But as a user of a consumer report, it does apply to the banks. We have the permitted uses, what's permitted to be in, the sharing limitations, a fair bit concerning the accuracy of information and corrections. A lot of this came through with the FACTA Act, who has access to it, and the disposal rule. Now, the disposal rule is not specific. It basically says you need to dispose of it properly. So in that way, it touches upon a data security piece, but it really leaves it undefined. So the disposal rule is disposal practices that are reasonable and appropriate to prevent the unauthorized access to. So fairly generic. I've got this grouped with the federal level only because obviously the PCI DSS standard is not a federal regulation, but it's going to be required by any of your card companies that you deal with. It has also become legal precedent for the enforcement of any unfair, deceptive acts and practices by the FTC. So it sets the standard of what's expected in terms of data security in those contexts. So it does have a little bit more force than simply a set of standards. Despite FTC or CFPB enforcement of this concept, your card providers, you will find that your agreements actually have penalties if you don't comply with this. And for some banks, given the complexity of them, some banks have chosen to they'll pay the violation versus pay for actually maintaining these security standards at 100%. So, speaking of standards, there are several different standards out there. There is no overall federal statute or regulation that says here's the standard you must use for purposes of data protection and security. Most banks and most of the bank regulators speak in terms of the NIST cybersecurity assessment tool, the cybersecurity framework, or the FFIEC CAT tool. There are other standards out there. Banks can choose these standards. They can make a combination of those standards. They can build their own standards. It's simply what's expected is to have a standard that you are trying to meet and test against to make certain that your framework is appropriate for your risk profile and the complexity of your organization. And from my standpoint, I always recommend that you do try to build in those pieces of, to the extent you can, perhaps NIST or CAT, simply because the regulators already understand those. If you're not following those, it's just the additional step of explaining why you have a different standard, which should not be a problem. It's just, where do you want to spend your energy? But again, you should have standards that apply to your organization, not things that are, for the mega banks. Moving on to the state requirements. We're going to touch upon data breach notification first. There are 50 different state laws, actually 54, if you count DC, Puerto Rico, Guam, and Virgin Islands. Everybody has their own set of breach laws. And I know in Kentucky you had a recent incident with the state unemployment agency. There's actually a whole second set of regulations and statutes that deal with information in the possession of state agencies. So we're just going to focus on that which applies to you as banks. So just briefly concerning Kentucky and the surrounding states, just to kind of focus on where your customers are likely residing. The common pieces that you see in these, and again in the banking context, is notice to affected residents if there has been an incident or breach. They generally include a concept that you'll be deemed to be in compliance, or that the statute is not applicable if the entity complies with Gramm-Leach-Bliley Act, except for Illinois. It does not have that specific reference to the crossover with Gramm-Leach. And the other common piece is that if you have more than 1,000 residents affected, you're going to be noticing to the consumer reporting agencies. Not all states require notice to the Attorney General. The Indiana does, no matter the number. Illinois, if there's more than 500. Missouri and Virginia, if there's more than 1,000 residents. There's a little bit of a split in terms of when that notice needs to be provided. So Kentucky, as well as several others, have notice without unreasonable delay. Ohio and Tennessee take a slightly different approach by actually specifying that it's within 45 days of discovery. Also in the financial services sector, we have the New York Department of Financial Services. Now you may be asking, why is this relevant to a bank in Kentucky? But basically any entity that is operating under a license, registration, charter, authorization with the Department of Financial Services of New York has to comply with this law, and it is very extensive. So you may be selling insurance, you may have mortgage borrowers, you may have some consumer borrowers that you need to really consider if this applies to you, or again, you already have the issue of whether you need to be licensed to conduct the activity, but if you do need to be licensed, this does come into play. And there's several pieces to it. Cybersecurity program, cybersecurity policy, and I apologize, I'm going to go back to the cybersecurity program for a moment. It's risk assessment, defensive architecture, response mitigation, the ability to restore operations, detection components. It's a very specific cybersecurity program that they want to see. If you don't fit within an exemption, you're also required to have a CISO, penetration testing, vulnerability assessments, multi-factor authentication, the encryption of all NPPI, and regardless of the exemption, you do need to provide a breach notice to the Department of Financial Services. That's in addition to the breach notices that you would need to be applying under the statute set that we just discussed to generally the consumers and AG, if that's applicable. So to have the italicized items not apply to you, fewer than 10 employees in New York, less than 5 million in gross revenue from New York operations, or less than 10 billion in total assets. So for a lot of banks, you do fall out of some of the more extreme provisions of this act. I know when it first came out, the thought of needing to put this in place in the time frame required and have full multi-factor authentication and full encryption of all NPPI was quite daunting. So this exemption is very helpful. And again, those are OR tests. So all components of this act came into effect on March 1st, 2019. You saw a phase-in, however, beginning in 2017 and 18. Now, the state privacy laws. This is where the California Consumer Protection Act, or Consumer Privacy Act fits in, excuse me. In 2019, I mentioned we did have Nevada and Maine pass their acts, and it's been kind of quiet and probably doesn't affect a lot of people here on this call. What's interesting is Maine actually has a much stricter act than California. Consumers there have to opt in for any of their information to be shared. It's not an opt-out, it's an opt-in. And as I mentioned, in 2020, we had several new pieces of legislation enacted. Now, to be honest, Florida, for example, has already died on the vine. Virginia continued its to 2020. Washington appears to be dead. It's not expected that a lot's going to happen, given other focus. Technically, there's 11 states that have pending legislation in different stages of the process. But right now, in terms of privacy, the states are really focusing more on things related to COVID, the contact tracing, what are people doing with the health screening information, those sort of things. This new legislation round, many of these acts are very similar to the California Act. So it becomes important to really pay attention to that California Act and how it might start becoming the standard to the extent we don't actually get federal legislation in place. Areas that differ, though, are whether there's actually a private right of action created by the statute. If you recall, Bram Leach actually does not have a private right of action built in. California does, and there's a fair mix in the new legislation of whether it does or does not. And private right of action, that's just a way for additional consumers can sue you directly versus the Attorney General with respect to any breach of the law. They also take differing approaches with respect to the Gramm-Leach-Bliley Act. And if you comply with that, we'll talk about that more in a minute when we get to get a little bit deeper into the California Act here. So, California Consumer Privacy Act, and believe me, there could be full half-day presentations on this act and all the requirements. That's not what we're going to do here. This is just a quick rundown of a few of the components. A consumer under the California Act is any California resident. And that becomes important when we talk in terms of that Gramm-Leach-Bliley exception, which is a couple slides away. It's a very expanded definition of personal information. So any information that identifies, relates to, describes, or is capable of being associated with or could reasonably be linked with a particular consumer or household. So it is extremely broad. It covers more than what you as banks would have. There is the enforcement activity is going to be beginning on July 1st. Just last week, the Attorney General issued a new set of regulations with respect to that enforcement. So we are looking to see how that will actually apply, and still reviewing those new regulations. Quick rundown of what's involved: notice before or at collection of the information, opt out of selling the information, right to know. Consumers have the right to delete the information. Data must be portable, and no entity can discriminate upon any consumer who actually exercises their rights under this piece of legislation. And just a quick, here are our recommendations of actually complying with the CCPA. And again, I know this act is very daunting. There are going to be situations that you really need to consider whether it applies to you. We'll talk about that in a moment. But if you do, here's just some quick notes as to what to focus on when you're working through your compliance pieces. And we do recommend that you work with counsel and other advisors if you are going to be subject to and complying with the California Consumer Privacy Act. Now, for the act to apply, the business must operate in California and meet one of these three tests: annual gross revenues in excess of 25 million, annually buys or receives, sells or shares information of 50,000 or more consumers, households, or devices. And it's really that one that brings in a lot of our community bank clients. Because here, consumer is a little bit broader. It's not just consumer, it's households, it's devices. 50,000 can be reached pretty quickly, or deriving 50% or more of annual revenues from basically selling California consumers' personal information. Now, what's interesting here is there's really two parts to this. And since it's just going to start enforcement, we don't have any case law or interpretations to really look at. But it'll be interesting to see how the idea of whether a business operates in California is discussed outside of those three standards. So what becomes, we're talking in terms of, are you really doing business in California? Is simply accepting customers going to be enough? This is a group of Kentucky banks. Are you promoting business in California? No, probably not. Do you probably have customers in California? Very possibly, if you have people move or children move off, go to college, those sort of things. It's going to be interesting to see to what extent that definition gets defined a little bit further, because there is definition to consider under the California Corporations Code, as well as definitions to consider under the Revenue Code as to what actually qualifies as doing business in California. So that remains to be seen, but at this point, I would suggest you focus on that concept of what's in the ABC thresholds there. Now, what is helpful for banks under the California Consumer Privacy Act is that it's subject, it's all personal information must be processed consistent with the CCPA. But there is an exemption for personal information that is basically collected, processed, pursuant to and in compliance with Gramm-Leach-Bliley. Now, this isn't an exemption from the Act, it exempts that personal information. Where this gets interesting for us as bankers is, remember I mentioned that piece of the Gramm-Leach-Bliley definition that ties it to basically providing a financial service or product. Think about what decisions you have made with respect to things like cookies or website traffic information. That is arguably personal information that's going to be covered by the CCPA. You may have decided, though, not to manage that pursuant to Gramm-Leach-Bliley in the concept that it's not in connection with a financial service or product. There is flexibility under Gramm-Leach as to what goes in there. Generally, cookies are included, but you may have treated them a little bit different, and it's important for you to go back and look at those things, because that convenience on the Gramm-Leach-Bliley Act scope for you that you may have taken may cause you issues with the CCPA. So something to go back and think about. Another important distinction here is that under the CCPA, there's no consumer purpose. It's simply whether the information is with respect to a California resident. So think of your business loans with guarantors, or even the information concerning your owners on business loans. That information is included in the CCPA, but you're most likely not managing it pursuant to the Gramm-Leach. So it's a good exemption to have here, but it's not complete, and just make sure you know the scope of it. Moving on, we also have biometric laws to consider. Illinois, Texas, Washington already have them. Arizona and South Carolina have pending legislation. And this will cover anything that you may have in terms of fingerprints, photos. What gets interesting is voice recognition is also included here, any sort of facial recognition. That will be swept up in the idea of biometric laws, so do consider that. Now, when we think about our phones and whether we have thumbprint access to unlock our phones or to unlock your accounts, remember that is information typically resting on the phone. That is not information that you as a bank have, unless you have arrangements that I'm not considering at the moment. But that is generally not information that falls in your realm. It's on the phone. Just some other laws to consider. We do have the model law for insurance agencies and companies. Right now there are 8 states. We've got one on a border to you, and that's in Ohio. It's a model law. I think, one other state I know, Indiana, would have taken it up this year. I'm not sure if it's even on their list to consider at this point any further. You also have the Internet of Things, which California and Oregon have already gone into effect, and that's basically requiring that there be some reasonable security features built into those devices that do have that internet connection, that do transmit information. Moving on to the General Data Protection Regulation of the EU. Obviously a very broad definition of personal data. It is built in the context of anything that can identify an individual person, specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. So it basically will encompass anything you might be able to know about an individual. Now, how does that bring, how can a Kentucky bank be affected by this? Because it's with respect to personal data of data subjects. And that's basically people in the EU. And it's also processing activities related to offering goods or services to persons in the EU, or monitoring data subject behavior that takes place in the EU. So where this comes into play is if you have clients who have moved or somehow opened, I doubt many of you have the ability to open account or have blocked accounts from foreign ownership, at least in this respect. But if you have clients, there are some banks, I think, in this list who are close to Air Force bases or other military establishments that do have an international population, or colleges, where the person then moves or goes back to the EU, takes their account, you do fall within this. Now that doesn't, at that point, because of the level of requirements that are built into this and the data management, you might want to consider a risk assessment of just how many clients you have that this may apply to presently, and that you do have some idea could affect to if they do return to the European Union. There are specific requirements in the Act concerning international transfers to and from the EU. The system in the US is actually not itself sufficient. So the way that we handle that here is a self-certification process under what's called the US-EU Privacy Shield. So the country, there's no inter-country arrangement made, but we do have this private ability to go through the Privacy Shield mechanism. Now, before we wrap up, just a little bit about the cost of noncompliance. And this is from the Poneman Institute, which they do an annual report. And this is actually the report through, I believe, April of 2019. So their new report should be coming out in relatively short order. But it's interesting when you look at these numbers about the average cost of a breach, when you look at what the global cost is versus the United States. A lot of this actually relates to just almost the immaturity level of the country in terms of having standard expectations concerning privacy that we have so many states to comply with. We have the average number of records is actually higher in the US, and we obviously have an average cost per record that becomes higher. Now these costs, they do attempt to factor in things like the detection and escalation, forensics you may need to employ, containment activities. They include your notification costs, post-breach responses, if you're offering credit monitoring, if you have to issue new cards, those sort of things. They also attempt to identify lost business, and that lost business actually represents 36% of the average cost that's stated up higher on the slide. And this includes things like downtime, lost customers, increased acquisition costs for new customers, reputational issues. So while it's included, in a lot of ways, obviously your detection, and escalation components are going to be very significant in your cost. But the reputational cost of actually having a breach is what I fear most for clients, when they go down this path of just what that's going to do to their reputation and their ongoing and future business prospects. Cost of noncompliance can also include regulatory fines. And just to give you an idea, and it's interesting, a lot of these state levels have gone to an idea of what's the fine if you have a violation. And whether it's intentional or unintentional is a big difference. For example, unintentional in California is $2,500, while intentional is $7,500. New York is even more disturbing. This follows just their general banking law penalty scheme. And let's see, $2,500 per day during which a violation continues, all the way up to $75,000 per day in the event of a knowing and willful violation. So keep these in mind. They can be very expensive just in terms of the regulatory penalties. You have the private right of action. What lawsuits are you going to be facing with respect to your consumers? You have UDAP actions by the attorney generals of the states, the FTC, and the CFPB. All these things can really add up. And then, of course, you may have legal costs to actually deal with these as well. So it can be quite a costly prospect should you have a breach scenario. And here are just a few, and I think Bob and Jean in particular will probably go into a little bit more of these concepts, but just ways to mitigate these. And that's having your incident response team in place and tested. Do not let an actual incident or breach be the first time you decide what you're going to need to do. Data classification and encryption, vulnerability scanning, actually apply your retention policies. I know that's painful, particularly if you have unstructured data, but it does save you in the end. Making those technology investment, investing in your governance, risk management, and compliance programs, your third-party risk management, just in terms of your contracts, in addition to actually auditing and testing those that have your customer information, and then building on those programs that preserve customer trust. And this is what helps you in terms of that reputational risk, having strong policies, customer protection steps, showing that executive commitment to this concept. So with that, I am going to pass this over to Bill, unless there are some questions, or you want to wait till the end for questions, Tanya?
So if you would like, you can go ahead and feel free to put your questions in the chat, or if we want, at the end, we can go ahead and, go ahead and talk about them at the end or right now. If you want to go ahead and put them in, it's up to you.
Okay, I think since we are at 1:42, we should probably let our gentlemen proceed with their presentations and go on, and we'll look for questions that you may add to the chat box.
Great. All right, and so now we're going to be passing the baton off to Bill Repast and Bob Deibert. So Shannon did a great job. For those of you who joined us, Shannon has experience as the Chief Legal Officer of a regional bank, as well as wearing the hats of Chief Compliance Officer and Chief Risk Officer. We're now going to have Bill Repast speak. Bill was in-house counsel at National City Bank and handled the bank's commercial, retail, and operations litigation, as well as Bob Deibert, who has over 20 years experience with data privacy and cybersecurity issues, and is our go-to person within the firm for electronically stored information issues and vendor agreement review. And so, and if hopefully Gene Price, who is with us at present, is a Rear Admiral at the U.S. Navy. He is the Deputy Commander of the 10th Fleet and Fleet Cyber Command, handling cybersecurity issues at the national level, as well as the implications of the same. And what they're going to talk about are stories from the front lines. We want to make this real world cases to illustrate just what Shannon gave us a great overview of, and the importance of the distinction between an incident and a breach, and why you want to make sure that you have the policies and procedures in place and are adhering to them. So Bill, do you want to go ahead and take it over? Bill? Bill, are you still on mute?
Bottom left-hand corner, Bill. Hey, Bill, the bottom left-hand corner of your screen should show how to mute and unmute.
All right. Can you hear me now? Jean?
Yes, we can hear you.
Fantastic. I just have too many screens open. I will tell you, I have been in banking for 18 years. I started when everybody was concerned about check cases, and I've always made the joke that my eyes have gone bad from trying to read the back of instruments to see whether these endorsements were actual or forged. But nowadays, we're just not writing as many checks. And one of the things that I thought was most important from what Shannon Cool was just speaking about is this third-party risk management. You know, when I first started banking, and I unfortunately, many of you know me and know how long I've been in banking. You know, the business of banking was opening up accounts and making loans. Now I think the business of banking is equally signing contracts with vendors, because the world has just changed. And one of the things we wanted to use this part of our compliance talk for was to talk about some of the real world issues and compliance concerns that are coming up in our banking world, sharing where we can without divulging attorney-client privileges, some of the important cases and how things are resolving and where the bank's practices have helped or have hurt them throughout the process. I think it's important, before I leave this first slide, to make sure that we all understand that what we're talking about helps and protects the bank's financial risks. You know, but money is finite. It's this reputational interest on this slide that I think is one of those areas that so many people simply don't get. That doing things improperly, having a failed compliance program in these areas, will hurt you, your shareholders, and the bank's interest in lots of different ways. There are generally two ways or I like to approach the issues here by first talking about the threat vectors. The fellow at the top is our bad actor, and he is going to choose two different ways to try to disadvantage you, the bank, or your customers. He's either going to attack the machines or he's going to attack the people. Generally, attacks on machines are what we often call account takeover attacks and many of our ransomware attacks. Many of you remember that Kentucky, unfortunately, was the state in which one of the very first account takeover attacks happened. And unfortunately, us at Frost Brown Todd got to have the opportunity to create essentially new law as we explored Article 4A and took a statute that had originally been created along with the operating circulars, Reg J, for wholesale wire transfers, and began to craft them to handle all forms of payment orders. And obviously, Article 4A of the UCC speaks about payment orders, but with these ransomware attacks, with the account takeover attacks, we really got to see the very first instance there. One of the issues that Shannon had mentioned was the biometric identification. I'm not going to get into the account takeover attacks right today, but we all know as we contract with our vendors and we get examined by our regulators, they're going to ask us about multi-factor authentication. Everyone knows there are three types of factor identification. Something you know, like a PIN code, something you have like your PIN card, or your debit card, or something you are. And this is where that biometric identification piece could fit in. Now, presently, not many banks are playing in this area. A few are trying with a very mixed success rate. But right now, those are the principal issues, something you have and something you know. What we really want to focus on from a compliance standpoint is the cyber attacks on people. This is where the greatest present risk exists for banks and for your customers. And of course, whenever a customer finds themselves a victim of a fraudster, it's usually a effect that has occurred to them in their bank accounts, and they're showing up at their banker asking for some help or for you guys to make them whole. And so what we need to do is understand a little bit more about these attacks on people so that we can better prepare our bank for both dealing with your customers, protecting their reputational risks, and also placing our limited compliance resources, whether it's people or dollars, to make sure that we're targeting the more likely and the highest risk areas. Here, just so everyone knows, business email compromise attacks, CEO impersonation fraud, your standard romance schemes, the Nigerian prince emails, whatever you might want to call, are those things that we categorize as cyber attacks on people. One of the things that those of us who practice in the payment space study vigorously is, where are the bad actors focusing their threats? There are several ways we follow this. One of the most important is the FBI's Ic3 report. And once a year, they go back and they take a look at its entire database of complaints, cyber complaints, and they look at where the nature of the types of attacks. There are 33 different categories they follow. Number one, by far, is the business email compromise attacks. And because this is far and away the most common and the most significant loss, both to your customers and to your banks, we're going to focus on that in some detail. But I also want to talk about the new number two, the romance confidence scams. This is, it is not interesting in a humorous way, but it is, unfortunately, there's a 40% increase in reported romance scam attacks. Now, again, for your financial institution, I don't suspect that banks are going to be the victim of your romance scams, but your customers will, and it appears to be one of the fastest growing. The FTC, which is another source that we follow for where the bad guys appear to be most active, says that this has increased 40% over the last couple of years. I put down item number 24. Remember I said there were 33 categories? 24 on that list, at least according to the FBI, are the ransomware attacks. These are the things that are capturing the public's attention. But according to the FBI, it's only the 24th most significant cyber threat vector right now. Now, personally, I do question the way the FBI calculates this number. One of the things you'll note is, while it only lists 2.1 million in losses, the FBI does not include damages to the business reputation. And as we all know, every cyber event has a finite amount of money that inadvertently or inappropriately exchanged hands. But the loss to the bank in reputation, lost customers, closed accounts, folks that should be doing some other job at the branch are now full-time investigators for cybersecurity issues. It is nearly unmeasurable. And the FBI recognizes they can't measure this. So I do think that ransomware, despite where it's actually listed, right there on showing on the screen, is actually a bigger issue and something we need to continue to focus on as we prepare compliance strategies. I take this slide just to drill down to Kentucky specific. The FBI breaks all these categories down by state, total losses, and I just wanted to share that in Kentucky, the FBI's Ic3 portal shows over 3,000 victims who have reported, or whose financial institutions have reported to Ic3, with about $17 million in losses. There is one issue that I always flag. I know many of you have had me out to your banks talking about different compliance issues or cybersecurity, or many recently on elder financial abuse. We are all very concerned about this, not only because we're good people, but because we recognize that a lot of our customer base is growing older and they have significant relationships with us, and our people at the branch very interested and very concerned about matters that involve, elder customers, and when they perceive situations where the customer is not being treated fairly. Kentucky has some very specific rules about elder financial abuse. The Consumer Financial Protection Bureau has also published some new rules. We do not want to let this topic take over today's issue, but I would invite you, if you want to have a branch training program one afternoon for your branch personnel, this is probably a topic that you might want to tee up, and we'd be happy to come over and talk to you guys about it, because this issue will come up. This is my prediction for 2020. You're going to have branch personnel wanting to speak to your folks. Oh, share my screen. Okay. I thought I had shared my screen, guys. Slideshow. Is my screen showing now? If you don't mind. Guys, I apologize for this. These were the screens that we have been talking about. This is where I was speaking about elder financial abuse. Ransomware is another hot topic right now that lots of our boards of directors and senior management want to talk about. It had sort of leveled off over the last 2 years, but the threat vectors the bad guys were exploring have been changing recently. In fact, in the first quarter of 2020, we see a 25% increase in ransomware attacks on public and private businesses. You might remember that the old school method was the spray and pray method for infecting the bank's computers in order to put ransomware on the site or in the machine. But now what we're seeing in 2020 is a much more targeted server-based approach to infecting bank infrastructure with ransomware. Ransomware, according to the FTC and others in the cybersecurity world, state that the average cost is $761,000 per ransomware attack. So you can begin to see that the FBI's counting of the costs has to be explained in some way that we presently can't reconcile, because this report is prepared by the Sophos group, who surveys annually somewhere between 5,000 to 10,000 IT professionals and have very good resources. And this is where they're reporting the average cost of a ransomware. Just to put things in perspective, smaller businesses, less than 1,000 employees, most of our community banks, of course, $500,000 is the average cost of a ransomware attack. As the business gets bigger, the average cost goes up. What is most interesting in the reports that we've been studying this year is that paying the ransom that is demanded by the fraudsters actually doubles the total overall cost experienced by the victim of the ransomware attack. And basically it comes down to, first of all, if you are infected with ransomware, please get on the phone right away and talk to your counsel about this. It's almost like a business operation anymore. It's like a deal, a business deal. And you need competent counsel, you need IT support, you need lots of different things, suggesting to form your response team when dealing with the bad guys here. But paying the ransom doesn't mean all is going to be well, because the ransomed documents are often returned, unencrypted often, but not always, in nearly an unusable format. You've got to reorganize, you've got to find documents. This is why the survey results appear that paying the ransom is not much cheaper than simply going back and using your backups to create the documents. I speak about the types of attacks, but the one thing I want to leave you with, among all the things that Shannon spoke about earlier, probably the number one part of your compliance program for cybersecurity defenses, particularly in regard to defenses against ransomware, is to make sure that your backups are part of your defense in depth. 56%, according to 2019's data, victims of ransomware were able to recover their encrypted documents through their own backups without having to pay a ransomware or a ransom, excuse me, to receive the encryption key. Also remember, as you study and you work with your guys from a compliance standpoint, this means backup of both data stored on premises as well as data stored in the cloud. Right? Next topic we want to get into is the real world situations. These types of attacks that we're talking about, and primarily now we're going to be talking about the business email compromise attacks because, as I mentioned earlier, the largest dollar and the most number of events. This is a situation involving a community bank. A bank that is going to, or a bank and its customer is going to experience a $2 million loss event. This is a New Jersey bank whose president, a senior executive of Crown Bank, began to receive, the bank began to receive on behalf of the wife of the senior executive, emails requesting wire transfers from her husband's account. Again, her husband is an executive at this bank. As happens in all cases involving business email compromises, what has happened is the wife's account has been lost to her control. The fraudsters are now impersonating and appearing to be the wife and sending emails. And the bank, who knows the wife, finds these emails very believable in both their tone, the terms used, and before they know it, 13 separate accounts or 13 wire transfers are initiated from the senior executive of the bank's accounts to a Singapore bank. Now, in this particular case, the bank's deposit ops rules, account rules, permitted email orders or requests to be made by email, which is what the fraudsters were doing, very cleverly impersonating the wife. But the bank was supposed to call when it received an email to verify that, in fact, it really was the wife. In our cybersecurity world, we call this an out-of-band communication event. They didn't do that because the emails were so convincing. They simply sent the email request on, they forwarded it to the email, or they replied to the email they received from the wife. Of course, the emails were opened by the fraudsters, who then created a plausible forgery of the wife's signature and sent it back. And the bank paid the money out. In this particular case, there's obviously litigation. I'm not gonna get into the details about the claims because I don't think this is really what we want to do here, but the bank is going to lose on its claim for coverage under the bond. And it's probably going to lose under its internet or computer crime policy of insurance. At this juncture in the proceedings, this is a very new case currently pending. The court found that most likely the bank is not going to be able to claim coverage under its insurance policies. But just the court wasn't willing to grant summary judgment at this time and is going to permit some discovery to take place. So part of our compliance program, as you know, and all our examiners go through these when they show up, is, do we have policies, practices, procedures? But a new issue is, where do we stand as a financial institution on our insurance? The last real world scenario I want to talk about is the situation I believe that's more commonly faced. Certainly, I receive numerous calls from banks whose customers have been victimized by a business email compromise attack. And once they realize they can't get the money back, they show up at the bank's door and ask to be made whole. And having a plan in place for doing this is something that we should begin to consider to protect both the bank's financial and the reputational risks. One of the first questions I always ask when they call in is, are we talking about a business account or a consumer account? We have different rules for both, as you all know. Our risks generally are larger in terms of the dollar amount when we're talking about business accounts, because often more money is flowing out of a business's account through a wire transfer or an ACH than it is a consumer account. But in this particular case, there was an attorney, not in Kentucky, but an attorney who had received an email that looked like it was from his partner. This email made it known that the hackers knew that the customer, the other partner, was traveling out of state, and that the email essentially says, man, I need you to do something. I'm out of state. I can't get to my computer. I need you to wire some funds for me. And in this particular case, it's $580,000 that they want, or that the other partner appears to want transferred from client A from the law firm's IOLTA account at the bank, this time to a China account. Well, the hackers have been watching it, and always will do. They'll be watching the emails. They know the pet terms that you refer to each other. They will know whether your CEO or your supervisor happens to be on a vacation, because there's so many different ways to learn this. And these bad guys, in this particular case, knew all this. They knew the pet name. They knew the actual IOLTA account number. And they used informal nicknames, the way these partners often spoke to each other. Well, Mr. Staffen, the attorney, called his bank, Bank of America, at 5:22 to order the wire. This wire was promptly made. Mr. Staffen then, and I underline the word then, because that's important, then picked up the telephone and called his partner to essentially brag, hey, I got this done for you. The deal is saved. What would have happened if Mr. Staffen had, or Attorney Staffen, had only called before he sent the wire instructions? But he didn't. But he called his partner and said, we got the wire sent. Well, that's when the OMG moment most likely occurred, and they worked diligently. It appears that they didn't leave any stone unturned. Their bank behaved properly, but they couldn't cancel the wire. And at the end of the day, the customer is going to lose almost all the money that was sent out by the account, except for almost $58,000, and is then going to go around and sue the bank. And that's why we have this lawsuit. The customer sues the bank, and that's what brought us in. Just an interesting tidbit. Once the bad guys were successful on day one in getting the $580,000 out, they called Mr. Staffen up the next day and said, hey, how about sending some more money? This time, let's really go big. But Staffen's onto it at this point in time. So the bad guys are clever, they're persistent, and they have simply no sense of morality. I'm going to avoid the law so I can tie this up, but business email compromise attacks typically cause the consumer to direct his bank to make a payment order. Payment order, typically wire or ACH. Wires and ACH are electronic payment orders. Payment orders are governed by Article 4A of the UCC, and the UCC is simple here, guys. Your customers may not like it, but this is where it ultimately comes down. If the transaction is governed by Article 4A, and think of all commercial transactions likely governing use 4A for its controlling law, if the payment order is received by the receiving bank, your bank, is the authorized order the person identified as a sender, the transaction is going to be good and valid. This doesn't matter whether the person calls you up the next day and says, man, I just got fooled by an email, or man, I really thought I was dealing with the Nigerian prince, or my bookkeeper believed that it was me who had sent her a text while I was on vacation in Florida, asking her to make a payment. No matter how good and clever the fraudsters were, if someone actually communicated to the bank and said, please make the payment, the customer is stuck under the law. That doesn't mean, as you know, we might not cut our customer a break, but the law puts you in control here in terms of whether we deal with the customer. From a business perspective, a long-standing customer might be treated differently than somebody else might be. But electronic payments are what's happening in our world today. The banking world's changed. There are incredible risks associated with this. Timing is more important than ever. When in doubt, please consider picking up the phone and speaking to others at the bank about an issue. From a legal standpoint, from working with the FBI, from several different standpoints, the sooner you can identify the risk event and the fact that it may be suspicious, even if that's all you have at this point in time, the more likely we can get the money back. For instance, the FBI has seen countless BEC compromise attacks, has a developed machinery in place almost, procedures and protocol. If we can get them accurate information about the transaction, and particularly the receiving financial institution quickly, there is a chance that we can get a recovery for your customer as long as we can move quickly enough. With that said, this brings me to the conclusion of what I wanted to talk to you about. I appreciate your patience in putting up with my inability to show you my screen right away, but I'd like to turn it over to Bob Deibert and Rear Admiral Price.
Thank you, Bill. And hello, everyone. I am a litigation member at Frost Brown Todd, and I have worked in privacy and data security, actually starting in the HIPAA litigation context in the early 2000s. That has sort of evolved to include incident response during the last 10 years or so. And also when clients wish to be proactive in anticipating and preventing threats to the extent possible. I've worked with Bill and Tanya and others in our offices to analyze those situations and help to the extent that we can. As a litigator, my focus is on the evidence. I look at the evidence of the program being put into place as it is supposed to be. Look at how the evidence of how the program is performing the way it is supposed to, and the evidence that demonstrates how things broke when they did break. So I typically look at evidence, and I think the evidence shows us where to go, and it's going to show the courts and the regulators where responsibility should be allocated to the extent that it should be. And I'll start with the slides. Yes. Can everyone see? Can everyone see the first slide, which starts with warning? The bootloader fingerprint. Can we see the slide that talks about the bootloader fingerprint?
No, you've got a moose on there right now.
All right.
Okay.
We are having so much fun with COVID-19, aren't we?
Yes, indeed.
No, we still have a picture of the moose.
And we're not seeing trending enforcement.
Nope, we're not seeing trending enforcement or any evidence. Hold on one moment, everybody. There we go. We're
Okay.
all engaged, Bob.
Okay, so now we're seeing the bootloader fingerprint. Okay. There are two points to make in this slide. One that I'll make now, and one that we may have time to discuss later. I was at a conference last year where I was discussing with some forensic experts the evidentiary issues in incident response, and we were talking about the different layers of security and different layers involved in an incident response. And we were talking about, in particular, the so-called boot sector attacks, which tried to disable an entire machine. And we were talking about a method of inserting, basically interdiction, interception, and alerting a user if something like that might have happened. And from that discussion, I came home and I didn't turn any malware loose on any systems, but I did simulate the approach. And when I rebooted, indeed, a warning came up that said something may have changed. There may have been this type of attack. Here's what you should do immediately to prevent further injury. And this reinforced that when we're talking about an information security program, we're talking about multiple layers. We have the device layer, what's built into the laptop, the phone, the desktop itself that we can do to protect against improper alteration or exfiltration of data. Then there's the operating system level, Windows, Apple iOS, Linux, safeguards, privacy and security settings in the operating system. And then finally, the application layer, Word, PowerPoint, whatever, Zoom, whatever we're using in the moment has its own security procedures. And what we find in a lot of attacks, particularly ransomware, is that the infiltrator is trying to jump from one layer to the other in order to do damage. So the threshold question for our security program is, how are we making these layers work together and making them less vulnerable to attack? And the first point that I want to make is in how we demonstrate that kind of compliance is to pick up on a point that Bill mentioned about exploitation of the increasingly elderly population. And we have financial trend analysis from December of 19 talking about the increase in suspicious activity reports. And then also saying financial institutions are a front line of defense against this kind of exploitation. Well, how are we supposed to do that? And one of the points that we want to discuss is who assumes the risk. Because what I am finding, and what we are finding in regulatory actions and in litigation, the more we rely upon automated processes, the more a judge or a regulator may say, okay, who's the person who is responsible for making sure that process is working the way that it's supposed to? Name the name. And so we have the issue of the program, what the program is intended to protect against, and who is responsible for oversight to see that it's working the way it's supposed to, or that when it didn't work the way it's supposed to, why not? And looking across financial institutions' websites just generally, I see an interesting divergence in the amount of public versus private outreach and suggestions, obviously not binding conclusions, on customer cybersecurity. Some financial institutions publish a considerable amount of information for customers. Others seem to publish little or none. But this notion of who assumes the risk and who is supposed to be warning customers when about possible threats to the financial institution, possible threats to their accounts, is something that we should include and address in the information security program, because customers are both a resource to be cherished, but they're also, depending on how they access their account, they also could be a threat vector. While we say all this, I think it's important to remember that financial institutions are often attacked, but you're not often attacked successfully. And that's because financial institutions, you generally do a good job in securing your perimeters and detecting any attempts at infiltration or exfiltration of data. And I think that going forward, as in increasingly remote environments, in increasingly hosted environments, proactive threat management becomes even more important to minimize, if not always avoid, the regulatory and litigation consequences. And that's why I want to spend most of my time talking about a specific ransomware case study. And this is a case study that is drawn from public records about a government ransomware attack. The advantage of using a public sector example, first of all, it's not a Kentucky example, so it doesn't implicate any of this firm's clients. Second, any of our Kentucky clients. Second of all, governments, either by choice or through open records or Freedom of Information Act, may have to be more open about the details of the attack and what they did to prevent or remediate than many private organizations. So looking at government instances can give us some insights into nature of attacks and how people respond, or how we may improve response. So in this particular case, what happened? This one caught my attention because a lot of my calls about cyber incidents occur around 11, 12 o'clock at night. In this particular situation, in the early morning hours of August 16th, 2019, more than 20 entities in Texas reported a ransomware attack. The majority of the entities were smaller local governments. And I think it ended up being 22 reported local governments that were attacked all at once on August 16th. This is a good study in disaster recovery, because by the evening of Friday, August 23rd, a week later, all of the governments had transitioned from assessment and response, trying to identify and immediately react to the situation, to remediation and recovery with business critical services restored. So they had sufficient backups, they had sufficient parallel methods of operation to recover their operations within a week or so. Within 2 weeks later, first week of September, more than half of the impacted governments were back to operations as usual. So this turned out to be roughly a 1-month exercise in cyber disaster recovery and apparently no ransom was paid. So the governments, in this case, were resilient. They were able to recover in relatively short order compared to what we've seen in some other circumstances, and they were able to do so without paying any ransomware. What was the nature of the attack? The mayor of one of the impacted cities said that hackers breached the city's network using the software of an IT company that had been hired to remotely manage infrastructure. And that software was also used by the other municipalities. So this is a case of indirect infiltration into the governments through a managed services provider. I looked up the software in question. It claims to be a self-hosted remote desktop software application that has remote support, remote access, and remote meeting capabilities. In other words, it's a remote help desk. There's an interesting question as to whether the remote meeting capabilities had broader application than the help desk question, but it didn't seem important for this particular situation because it looks to be a compromise of the third-party service provider. When individuals talk to the service provider, it turns out that the actual service provider was the licensee of the publisher of the actual desktop software itself. And the publisher, the owner of the software, said that an on-premises version was used because the managed service provider partner used an on-premises version of the software. The publisher didn't know at the time if the provider had the most up-to-date version of the product, if it had multi-factor authentication turned on, or if it was vigilant with patches. The publisher said, we literally don't have any access to the logs of the configuration. Unless the licensee calls us and asks us for support, we don't have the ability to see that. The implications for third-party risk management are several. First, when third-party risk management is brought in for remote hosting, remote management, are you bringing in one partner or actually more than one partner? Is the person providing the services the licensee of someone else? Are they licensing several different applications? And who is responsible for security? And how are these security protocols monitored at each level of this hosting chain? Understanding the third-party risk chain is becoming increasingly important. And it was very important here because there seemed to be a gap between the services provider and the actual publisher, the owner of the software, who would have been responsible for updates of the software itself. Turning to the question of preventive opportunities missed. What happened here? How was the infiltration able to succeed? First of all, it appeared that patches were out of date, because patches specific to this type of ransomware infiltration had been issued from Microsoft in the fall of 2018, almost a year before the incident occurred, and from the publisher of some of the web hosting software in the spring of 2019. It can be prudent to wait for a little while after a patch is issued to make sure that the patch doesn't bring things to a standstill or otherwise cause more trouble than it's supposed to remedy. But waiting 6 months to a year or more to keep systems patched, that can become problematic. So part of the security program, how often, how quickly are patches deployed, and how is that patching going to be validated? That is, if it actually has been put in place like it should be. Texas itself has suggested some other issues for consideration. In this case of remote administration, of user systems, whether by internal staff or an outside provider, first, they recommend only allowing authentication to remote access software from inside the provider network. So besides the device layer, the operating system layer, and the application layer, we now have the network layer. And how are we going to allow remote access inside that perimeter? Are we going to allow it outside the perimeter? The next recommendation, also which was not being followed, was to use two-factor authentication on remote administration tools and virtual private networks instead of the system's built-in remote desktop protocols. Actually, the United States Department for Health and Human Services recommended disabling external use of remote desktop protocols in May of 2017, more than 2 years before this incident occurred. So again, the question is how, and this can be accomplished through system mapping. How are the systems relating to each other, and what systems are allowed to communicate to each other in what ways? The next recommendation is to restrict. Do you have restrictions on the sources that can contact your network? In the Texas case, the recommendation that came out of that was to block inbound network traffic from Tor exit nodes. Tor stands for the Onion Router, and it had its origins in a United States Navy project that has become a global network for anonymous communications, for better and worse. Traffic is encrypted going into the network. It's repeatedly encrypted until it exits in order to disguise the ultimate sender and destination. Does the financial institution have any interest in allowing anonymous or randomized external contacts into the network? Can those be blocked? In this case, there also they also found that network traffic to implement the ransomware was going to an internet site called Pastebin. Pastebin is a website that allows anonymous storing of text strings, such as programming code that can be used in ransomware, for a user-determined length of time. So it's kind of like actually it could be as little as 10 minutes to self-delete and purge from the website. Again, does the institution in its security program have an interest in identifying and blocking outbound traffic to sources that have been flagged as potential conduits for illegal activity because of their provisions for anonymity or short-term purging of information? And then the last specific recommendation was to use detection and response mechanisms within the host or within the organization to detect PowerShell running unusual processes. Just quickly, PowerShell is the current version of a command line interface for Windows, and it's expanding. I believe it's expanding for use in other systems as well. We historically called it the command line. And what it allows is running scripts which can be encrypted, which can be interpreted so that they won't trigger traditional antivirus software because they don't have the signatures of typical viruses or worms or other kinds of malware until they're actually run within the system. Researchers with IBM's X-Force, which is a cybersecurity branch of IBM, found that in 2018, just 43% of the attacks utilized any kind of locally installed files. Instead, they used the majority used PowerShell scripts, duping users to download the scripts instead of installing files and just running the scripts with elevated privileges. So the question for the information security program is, what do we have in place to detect and limit the use of scripting, of automated scripting on user machines compared to administrator privileged machines? What do we have to prevent the escalation of privileges on user machines? And this is where another piece of the evidence that we look at are Windows event logs, because there are event logs that record what happens with PowerShell and other parts of the Windows operating system, so that we can see what was going on. We can see what should be going on, And then in an incident, we can see what else was going on and use that both to detect and prevent. What else can we learn from this case? This particular ransomware was called, actually has a number of different names, called Revil, Blue Background, Soden. Most often it's called Sodinokibi. Allegedly distributed by an organization on a commission basis. Supposedly, it's published that the affiliate share starts with 60% and goes up to 70% after the first 3 ransom payments. The rest is a royalty that goes to the proprietors of the code. The ransomware is forbidden to be used in the Commonwealth of Independent States, Russia, including Ukraine, Russia, Belarus, and Moldova. So this apparently is an organized crime group sympathetic to the former Soviet Union. And it's run on just like a business, an illegal business. The ransomware operates through a user clicking a link that downloads a script file. This file executes scripts to bypass user account control or otherwise obtain administrator privilege. And then it triggers file encryption, and it also seeks and tries to wipe up backup files and folders. In a different incident using this kind of software, and this is another point for the information security program, the trick is that the attachment had a .doc.exe extension. Since Windows hides file extensions by default, the embedded object looked like a regular Word document with the right Word icon. Once opened, it opened the ransomware attack on the computer. By default, Windows hides file extensions for files that it thinks it recognizes, including executables. So if a user hovers over ransomware with this double extension, they don't see the they may not see the executable. They'll only see the Word document. They'll only see the PDF. They'll only see that it looks like a text file. They may not know, they may not be able to recognize that it's a malicious executable. So one of the points to consider for the information security program is stepping users through Windows privacy security settings so that users are familiar with and therefore more accountable for seeing and how their systems are being used and how they might be misused. So the points for response and recovery. First of all, how many backups do you have for each system, and how are those backups stored? Are they stored in separate places using separate tools so that ransomware that is attacking the system and looking to wipe backups on the system can't find the additional backups? How well does the information security program synchronize to your disaster recovery plan? Second point, do you require multi-factor authentication for all out-of-network access? Employees, consultants, customers, everyone. Do you block anonymous traffic to and from the deep web? Or do you block traffic from anonymous sites to and from the deep web? Do you whitelist, allow only selected sites, only selected URLs? Do you blacklist, identifying from lists of suspicious sites that are available? And finally, do you log and limit user machine systems exercise of PowerShell or other administrative level system commands? How do we keep control of that in the organization? Those are lessons from Texas that we can put to good use anywhere as part of the information security program, but also we need to identify who is going to be responsible for keeping track of those pieces and following up with them continuously to make sure that they're working the way they're supposed to, because the criminals are evolving as fast as the technology, and because they're not concerned with following rules, they can get an advantage. They can get an advantage over us. Tanya, should I give the volunteer homework assignment, or do we want to save it for another time?
So let's save the homework assignment for another time. Although I think, Bob, you really shined a spotlight on the importance, for our information security officers and information security folks on this webinar. It's important that you are in constant communication with your compliance folks. The one thing that this program isn't able to deal with today, just given the time constraint, is bridging the gap between the information security folks and the compliance folks, so as to ensure that the bank's policies and procedures speak to one another and complement one another, to ensure that the bank is in mitigating risk and making sure that it has all individuals on the team on the same page and acting in concert with one another. If anyone has any questions, please feel free to put it in the chat, or just unmute your microphone and feel free to ask a question. Obviously, we can't render legal advice, but given the current situation, I know that as Bill mentioned, instances are unfortunately on the rise, and as contact tracing becomes more prevalent, I think we're going to see even more instances of breach. And as Bob said, they're using your voice, they're using different forms of malware attacks that Bob talked about. And it's just vitally important that we stay ahead of the bad guys in this case. Bob or Bill, is there anything you want to add about what you have seen or are sort of on guard about right now, given the current climate that we're all living in right now?
Well, I'd be interested in Gene Price's thoughts on what he's seeing at his level, maybe whether it's state actors or just otherwise, where he sees, the government focusing its concerns or attentions, etc.
I agree. I think that Gene's got the broadest perspective of any of us. I think that the notion of continuous compliance, I think, is very important, because it can be all too easy to handle an incident and then turn your back and hope that it's gone away, when in fact, once someone is on the hacker radar, it may be more likely for them to come back. I think continuous vigilance and continuous foresight, I think, is the most important factor.
And Bob, was Gene able to stay with us, or did he have to take a call of even more importance given his?
I see him.
Yeah, I'm right here. Sitting here looking over here. So anyway, thanks, Bob. Can you bring me up that last slide, and I'll run through this.
Admiral to the bridge.
All right. Thanks. Hey, guys, how y'all doing? I want to finish where we started. There might be some questions, but this, if in-house counsel are asked to do so much. You guys have to know about privacy. You have to know about the UCC. You have to know about the SEC. You have to know now about technology, and not only technology, but the cybersecurity that protects the technology. So what I wanted to do is just really run through at a microcosm what we're talking about. This is, I'm in the Navy, a reservist, but I'm on active duty right now. I'm taking a break for a little while to work with my partners because they're fantastic people. But this is called the Cyber Kill Chain. It was developed by Lockheed Martin, and they did it in response to the repeated hack attempts that they saw. They were getting hit by, and this is not classified, the Russians, the Chinese, the Iranians, the North Koreans, and then criminal actors as well. It went on and on and on. And they had the idea that they could just break it down to bite-sized chunks and then look at each chunk from the perspective of how do we stop them at this level, then we will be better informed and better able to prepare for what we have to do and then deal with it if it happens. So this gets a little bit nitnoidish. Most of it really should be captured in that incident response plan that Shannon started with. I cannot emphasize the importance of knowing what you should do if something like this happens, because you will need to act very quickly. So many systems are automated that once the bad guys are in, you don't want to pull the plug on everything, but you have to know where to pull the plug. Where are you segmented and things like that. So here's from the bad guy perspective, and I'm just going to play the bad guy. I'm going to start out by what's called reconnaissance. I'm going to use social media. I'm going to use active scanning. I'll use passive scanning, and scanning is just where I'm looking at what you're running. If I can see that far into your system, I'm certainly going to see which ports you have open and which ones you have closed, which ones are encrypted and which ones are not. And that's going to give me some hints about who I want to go after. So in that reconnaissance, it's usually driven by motive. And it's like the bank robber was asked, why do you rob banks? Well, that's where the money is. Same thing here. If they're coming after you all, it's usually to defraud for money. It's not going to be necessarily for espionage. So the reconnaissance, when it comes to things like social media, I'll just throw you a quick example. The USS Higgins several years ago was out in the Mediterranean on a patrol, and they were getting ready to pull into Haifa, Israel. And these guys all had Facebook, and they're communicating with their spouses back home. And so when they got into Haifa, these four guys, all men, they were out of San Diego. They called back to San Diego to talk to their spouses. And they called home, and they said, hey, sweetie, how you doing? And their spouse said, oh, we're great. Did you get the money? And the sailor said, what money? And the spouse said, the $400 that I sent you. What had happened was they had been trolled on social media, Facebook and some other things, and they had gotten some information about where these people lived. And then they were able to get which bank they were with. And that's all they needed. They were able to get the spouse to pull some money out and then send it to a Dropbox in Haifa with the instructions given by the bad guys. And it was all enabled because people were talking on social media about things that were really kind of private. So that's the kind of reconnaissance. That's how reconnaissance can work for the bad guys. But once they figure out their target, they get a good idea of what kind of firewalls, HBSS, host-based security systems that you're running, what your AV looks like, whether it's Norton or something else. Then they're going to weaponize things. And they're calling. I'll call them back here in a minute. So what they want to do is put a back door into your system. That's where they can come and go as they need. And they're going to put that together with an exploit that will enable the exploit to detonate within your system in some way. And it's automatically done usually. Just 4 or 5 years ago, this is largely a manual process. But now I think your IT people will tell you it's almost all automated when it happens. So the delivery system will usually come through email, through maybe visiting a malicious website that they're sent a link, go to this link, and then the website will download something they don't want. It can be done through removal media. It can be done through a brute force attack, if you know where that is, where a computer program just tries a number of password attempts that the reconnaissance has told them these might work, QWERTY or 1, 2, 3, 4, 5, 6, 7, 8, whatever it might be. And if you don't have a timeout feature on your password, or a number of failed attempts limitation, brute force can work. And so once they get done with that, they will take a look. They'll get on that single system usually, and then they're able to look from the inside at those endpoints, the firewalls. And if you don't have geo-blocking, which is where you're blocking traffic from certain countries, like the Ukraine's a good idea to block. Of course, that gets kind of dicey depending upon how big your international banking practice is. But Russia's another big one. They can get in lots of different ways. And the thing that you all ought to be really aware of is the FBI yesterday issued an update on mobile banking. Apparently, mobile banking apps have increased in utilization and download by over 50% since COVID started, just in the last 2 or 3 months. So it's an incredible increase in mobile banking apps. So what the bad guys have started to do is they're putting applications into Google apps or Amazon apps or pick your app store. They're trying to get their apps in, and there's this particular app that's been weaponized to have an overlay, so to speak. I'm trying to put this in layman's terms. An overlay where it just sits, once you download it, it just sits on your mobile device. But when it sees that you've got a banking application opened, it knows to overlay the entry of the data. It becomes a keylogger of sorts. It knows to overlay that entry of that data onto their website. So they are seeing in real time what the customer, not you, the customer is putting into their website. And then they automatically allow that information to go back to the banking website. Why do they do that? Well, they've harvested the credentials. They know about the password. And then late at night, they can come in and start taking what they want. And the FBI report is public. It was a consumer report bulletin. I just saw it early this morning. So that's the sort of thing that's going on too in the delivery and exploit area. So exploit, of course, is where they're targeting your operation system or an application vulnerability like we just talked about. It can be on yours or theirs. And it's usually an executive code thing. On the installation piece, this is where they establish persistence. They want to look like any other part of your operating system. They can do it with endpoints. They can do it with, an endpoint is anything on your network that's not protected is a vulnerability for you. Internet of Things, the IoT problem you've probably heard about. There was a report of I believe it was a casino in the United Kingdom that was hit through their aquarium. Their aquarium the water temperature was regulated through the internet. And it was an automated thing. It was web enabled and it was not protected, but it was behind the firewall. So the bad guys got in through the IoT that controlled the aquarium, vectored into the core of the system for the casino, and got over $1 million that they took out in just one night. So it just goes to show how vulnerable we can be if we don't know where all our endpoints are, which are printers, Internet of Things, not just the individual systems that are protected by a host-based security system. It can be just about anything anymore. But once they get in there, they can be stymied if you've had a layered defense. I think that Bob and Bill both talked about this. It's not just host-based security systems or HBSS. It needs to be Hawkeyes, internet intrusion detection systems or intrusion protection systems, really strong passwords, just a multitude of things where if you layer those defenses at every single piece of this intrusion kill chain, you're going to be much better off. But once they're in, they get to the command and control or the C2 of the system. And with that, none of it's good at this point. This is your last best chance to stop them. That's when they're inside at least one system. What they will want to do is start harvesting credentials. And they harvest credentials so they can get into a sysadmin account. one of your IT administrators. And once they get into the sysadmin account, then they can elevate their privileges and get into the DNS, the domain name server, and other places. Once they get in there, they typically can go anywhere they want. And we've known from experience now that since about 2017, there are lots of tools that will enable that. So it's absolutely critical not to be just monitored to the web at your IPS sites. It's also very important to be internally monitored, especially for banks. And I'm sure that you guys are to some extent, but knowing how that works will help you do your job if you have to deal with this. And then the action piece, that's where they take what they want, smash and grab. And the days, FireEye, Verizon, Department of Defense, they have been noticing that the days without being discovered has gradually gone down, down, down. Since 2015, it's gone from over 200 days to under 100 for a persistent threat. So we're getting a lot better, but this is where they still can get in and they'll collect files, encrypt them, and then they'll exfil them. And then they'll prepare false money laundering devices or just steal things. So it all comes down to, again, what Shannon was talking about at the beginning. You've got to have a plan ahead of time. You've got to know who is required to do what. And there was a decision that came out very recently about a law firm was called in to, this is the Capital One case. The law firm was called in after a intrusion by Bank One. And it was already the company that the bank was using. So because of that and various other reasons, even though they were hired by a law firm, the investigation of this 100 million users was not deemed protected. And right now, the judge, just a couple of weeks ago, ordered all the investigation to be given to the plaintiffs who are after a lot of money. So you need to know how this is handled, and probably ought to be familiar as a bank with the Capital One decision. And it's posted on our website by Victoria Blackman's one of our people in Columbus. And anyway, I'll stop there. I think I'm over. Tanya, over to you.
Great. Okay, well, we want to thank everybody for your patience as we navigated through Zoom and using this platform. But as you can tell, the knowledge is there, and each individual on our team brings a different sort of toolbox, and we use the tools of each of the people on the team to make sure that, as Jean just noted, that the problem is tackled correctly, and that the timing is there, and that we make sure that we do what we need to do to get the bank as protected as possible. And so again, want to open the floor to any questions that anyone wants to put into the chat box. We're happy to address those now, or we're also happy to talk offline about any questions or concerns that you have or are seeing at your particular financial institution. But knowing that this is part one of a two-part series where we'll go into, again, bridging the gap between your compliance folks and your information security folks, so that, as Jean just noted, the bank's acting in concert. They know who needs to do what, and that the policies and procedures that are in effect at your institution are being adhered to and are current. And please know how much we appreciate your time. Natalie or Jamie, any questions or anything that you need from our end?
No, just a note to everyone on the call is Tanya's going to send us an updated slide deck, so we will get the slides out to you all. And like she said, 2 parts, so we will get with them on dates for a second follow-up to this, and hopefully be able to get that out to you soon as well, and you can sign up. And if anybody has questions or needs contact information, you can reach out to us also.
Great. All right. Well, thank you everyone for your time, and we want to be respectful of it. And so we look forward to part 2. Thanks
Thank
again.
you.